Hey everyone, welcome again to another episode of DarshanTalks. I'm really excited to be here. Our guest for today, and I want to, there you go. We've got some music going now. uh, our guest for today is going to talk a little bit about patents. It's going to be Patents 101. We can talk about this in extreme detail, or we can actually get into this a little bit less. But the goal is to explain Patents 101 for today. And how it might apply to the pharma industry, but really more at the overall level, if you will. We also are going to use this. So anyways, if you are bringing out a new product, if you're curious about whether your product is patentable, whether it should be patented, or any of those questions, you probably want to listen into today's conversation. Our guest today is really interesting. We've had him on before. It's always a pleasure to have him on. He is he's a shareholder and co-chair of the IP group at Stevens & Lee, which is a law firm based. It's based out of Pennsylvania, but I know that they are all over the Eastern Seaboard, actually. So I think it's almost 200 lawyers now, isn't it?
Yes.
Okay. So really exciting time to be part of this. So I'm going to ask you more about that as well. I do also want to emphasize our guest's name is John Maldjian. He's been on before. He's talked about trade secrets before. This is a DarshanTalks live stream. I am your host, Darshan Kulkarni. I'm an attorney. I'm a pharmacist, and I advise companies with FDA-regulated products. I do have to emphasize both of us are attorneys. We're not your attorney. I am a pharmacist, but I'm not your pharmacist. So this is neither legal advice nor clinical advice. These are intended to be educational in nature, and they do not necessarily reflect the opinions of the host, the guest, our employers, or our clients. If you like what you hear, please leave a comment, please subscribe, please share. You can always ask our guest questions. I know we appreciate that. You can find me on Twitter at DarshanTalks, or go to my website at DarshanTalks.com. You can actually find John on Stevens & Lee, actually, at the website, and I'll put that across the website, across the screen as well, so you should be able to see it. You can also reach him via email at john.maldjian@stevenslee.com. You can also find him via his phone number at 609-718-0979. That's 609-718-0979. And John's kind enough to share the Stevens Lee website, so I'm going to do that as well. So that's stevenslee.com. John, how are you?
I'm good, thank you. How are you, Darshan?
Good. It's been a busy couple of days, busy couple of weeks, and it seems to be getting better, which I don't think any of us are complaining about.
Yeah, you mean weather-wise, it's been getting great. Yeah,
weather-wise, summer's here. So it's the perfect time, right, to sort of take some stock, to figure out where you are. If you are bringing a new product to market in the pharmaceutical industry, now is a good time to start thinking, well, how do I protect myself? Because things may be a little bit slower. This is a nice time to sort of recapture and sort of solidify your foundations, if you will. So Let's start with the basics. What is a patent?
What is a patent? A patent is a limited right granted by the government. Let's stay with the U.S. for now, but we can go into international patents later. But in the United States, a patent is a limited right granted by the United States to prevent others from making, using, selling, offering for sale, or importing that which is covered by the claimed invention. So that's a lot of words. Let me break it down. It's basically, as long as you meet the requirements for what a patentable subject matter is, an apparatus, a method, a process, certainly pharmaceuticals, nutraceuticals, any type of, life sciences. As long as you meet that criteria, you have to then meet the criteria of non-anticipated and non-obvious, and you can get yourself a patent, which will give you the right. It's a limited monopoly to give you a right to prevent others from doing what you're doing for a limited time. Now it's 20 years from date of the first filing of an application. So it's a strong protectable right. Once you patent issues, it's presumed valid, and it has to be overcome by clear and convincing evidence in a court of law. So it's a very strong right. And it's one you could use to assert, to monetize, and what have you. So Good.
So you said a really important thing that I want to take a moment to clarify. You said it's the right to prevent others from practicing your invention. Why is it not a right to practice your invention? Why is it a negative right?
That's a good question, Darshan. A lot of folks miss that up that thought. The reason for that is there might be someone else that has a pioneering patent out there that is already practicing something similar to what you're doing. You happen to come up with either something different or an improvement thereof. But because someone else has a patent already, you might not be able to practice your own invention until you somehow work a deal out with the parent or the original or pioneering patent owner. Meaning that if you were to practice your invention, even though you can get a patent on it, you might be walking on the rights of somebody else who came first and had a more of a broader protection or a pioneering patent. So it really is a preventative right to stop others from walking onto your, I always use the real estate analogy, walking onto your property and doing what you have within the four corners of your property or within the fence of your property. But if your property is part and parcel to someone else's property and you, like a Venn diagram, enjoy the combined area, well, they can't practice what you're doing. You can't practice what they're doing. But perhaps if you cross license or do something like that, you can both enjoy the spoils of your patent. So that's why it's a negative right. It's not a right to do anything. It's a right to stop others from walking on your property.
So in the real estate world, you have land surveys, and you can go out there and look at what the land surveys are, and I can go and someone can tell me this is your property, this is someone else's property. If I'm in business, if I have this brilliant idea, I'm a PhD student out of, I don't know, Caltech or MIT or whatever it is, or Harvard, and I've come up with this idea. How do I know that this is something that no one else has discovered before?
That's a very good question, and really a great place to start for all folks that come to see me. It's not required, but I highly recommend a patentability search, which is what you're referring to. A patentability search searches databases both in the United States and outside the United States, if you're considering to filing your application abroad, to see whether or not something exists. We have USPTO is one database, and we have other databases that have patent applications that have been published, and even sometimes things called non-patent literature, NPLs, which we can search for. And what we're looking for to see is, again, goes back to my original point about criteria for getting a patent. Is there something out there that is already existing that would knock your invention out of it? And what I mean by that is, in the United States at least, and it's true in most other countries and regions, you have to have a new and non-obvious invention in order to get a patent on it. The government's not going to give you a patent on something that's already been out there in the public domain or has been patented already by somebody else. Thus, they have their own property. So to your analogy, the real estate property, I want to do a title search. I want to see what's out there. This piece of property that I just came up with in my head, does it exist already? Did someone else come up with it in the same or almost a similar manner? So not to jump into, sections of the Patent Act yet, but I think it's important to talk about anticipation and obviousness, because those are the two big criteria for that patentability search. So when I'm searching, or when my group is searching for patentability, they're looking to see whether the invention is anticipated. That's section 102 of the Patent Act. Is it anticipated? That means, is it exactly out there in at least one reference, or potentially a reference in some inferences? If it's not, then you pass the anticipation test. But then the next question is it obvious? And that's really where a lot of these inventions get hung up in the patent office. Is it obvious over the prior art? And that question really comes down to a bunch of factors, which I'm not going to get into today. But effectively, it's saying, okay, you don't have the exact thing out there in the prior art, but would it have been obvious to take what's out there in the prior art and combine a couple patents together, or a patent and a non-patent literature together, or anything out there that's published that an inventor, that a person of ordinary skill in the art would be aware of, to combine those things with motivation to come up with your invention? And if so, the patent office will say, it would have been obvious to have your invention, even though we didn't see it in one particular reference.
So it's funny you mentioned this patentability search, and you talk about USPTO's website, for example, I'm now currently, say, that chemistry PhD student. I feel like I'm doing cutting edge research. I'm pretty sure. I mean, I'm the one doing the research. I know that there's no one else out there in the world because I'm reading all these documents out there. Um, I'm I'm a PhD student. I probably make 30, 40, 50 grand. I'm not sure I'm ready yet to meet John. Where do I start doing the initial searches? Because I know I can go to the USPTO website. What do you think about like the Google patent search? Is that a good one, or what's your take on it?
Yeah, sure. Google Patent Search actually gets its data from the USPTO and other databases throughout the world. So it's a great one to start with, and really sometimes end with if you find you're knocked out. Now, if you don't find you're knocked out, that's the question: is now what do I do? Do I continue to search? Do I hire a search firm? Do I hire a firm like myself, a patent attorney? It can get somewhat costly, especially if you're a PhD student. You're still on stipend or what have you. But it might be what I say. It's an insurance. It's an insurance plan. You're buying insurance by doing a search versus spending the larger amount of money to file a patent application and then finding out at the Patent and Trademark Office that it got knocked out. So to me, it's worth doing investing the cost to do a search to just see what's out there. Number one, it tells you if you're going to get knocked out. Number two, it's going to help you draft a patent application that would be better than if you had not known what's out there in the prior art, because the patent attorney will draft claims that avoid the prior art. But to answer your original question, you can do a lot on your own at the USPTO and other search engines like Google. eSpace, Net. There's a bunch of them out there.
Interesting. So now I'm this chem student. I've realized that, you know what? Turns out there's really no one else out there who has my idea. The initial Google search suggests that I may have some wiggle room here, some potential ideas here. So is this the moment I call John, or should I have something more? Like what do I need to consider?
Good question. In the past, you had to have what was called a working model, whether it was pharmaceuticals, mechanical, electrical, what have you. Now you can achieve that through what we call constructive reduction of practice. So actual reduction of practice would be building a model in whatever form, making sure the formula works or whatever you're doing. Now, as long as you know it would work for its intended purpose as an engineer or scientist or a chem PhD, that's all you need. And then we take over from there. Either myself or someone in my group who have technical backgrounds will be able to work with you, the inventor, to get through whether or not we think it's going to be operational or work for its intended purpose, and prepare and file a patent application that describes what you've invented. Now invention equals conception, reduction of practice. What is conception? Conceptions it's something in your head, but it's malleable enough to be able to put it down on paper. It's not nebulous such that you can't describe it. If you can describe it to someone else and put it down with some sort of detail, that's considered the conception. The reduction of practice, again, can be done with the help of a patent attorney, drafting a patent application and reducing the concept down to practice. And that combination equals, an invention. Whether it's patentable or not is another question. The good news is, to your specific question, is, what do I do? What's great about the United States Patent and Trademark Office, you can actually go to the Patent and Trademark Office as a PhD in chemistry, who, is barely getting by or what have you, and file your own patent application.
Okay.
There are offices there that help pro se inventors. It's set up that way because, unfortunately, in the United States and elsewhere, it's usually big business. The big companies are the ones that are able to file these applications because they can be very costly. So the PTO has allowed for a vehicle or an avenue for individuals to do the same thing and not spend too much money on patent attorneys. Of course, as you remember, if people go back to the trademark discussion we had a couple of weeks ago, you're at your own risk. But if you can research it and try to do a good job and look at samples, you might be able to get something that's halfway decent on your own. And it's totally available to you at the PTO. Would I recommend it? Not usually. The reason for that is you're looking at a patent attorney who has had years of experience, in my case, over almost 30 years of experience of knowing what to do, what not to do in these applications, right? It's like anything else. You go to a professional because they've had more years concentrating in that area than you did. But again, of course, it's available to you. So to answer your question, they can go and file a patent application on their own, and they can file one of two things, one of two types, a provisional application or a utility non-provisional application. So if I may jump into that, because that's kind of where they would go next. A provisional application is a placeholder. It does not get examined. It expires in a year from the time you filed it. But what it does do is it allows you to put a place in the sand, a placeholder. It allows you to lock in a filing date of your invention. And if you are concerned that there's others researching in your area, or you just feel like someone's going to steal your idea, or you want to disclose it, you should most likely file at least a provisional application to get something on file. Once you do that, you can do a couple things. You can put patent pending on whenever you talk about your invention. You can go and seek possibly some investors and say that you have an application on file. And you can go and freely talk about it without potentially losing your rights to file in the United States and abroad. Reason for that is in the United States, you only have 1 year to file a patent application once you've disclosed it or offered it for sale or sold it or even secretly offered it for sale. So you really should do the filing first before you disclose to any third party. And so the provisional is a lot less expensive than a utility. So even if you were to come to a firm like mine or Stevens & Lee, we would be able to do that for a reasonable amount of money versus a utility application, which takes a lot more time to do.
So what is a reasonable amount of money for a provisional?
Provisionals, depending on how much information you, the inventor, can give me, we could do it as little as $300 to $3,500 because it's a quick and dirty filing of just the substance. It doesn't have the bells and whistles. It usually doesn't include claims, which take a long time to draft and are very important to the utility application. So we could really get it banged out and filed within that amount of time and money, versus a utility application, which could be 3 times that amount, $9,000 to $12,000 for a regular utility. Because it really comes down to the amount of hours it takes us to draft it and make sure it's got claims properly and drawings if necessary.
So is there anything that stops me from going down to a utility patent directly? Do I need to file a provisional?
I recommend filing a utility application at all times unless you're in a time crunch or you don't have the budget at this time to do a regular utility, because the regular utility, it's going to give you more value in the end of the day. You'll get it filed quicker. It'll start getting examined quicker, within a couple of years of filing it. If you file provisional and then you have to convert that to a non-provisional within a year of that provisional application, you've now lost a year of time in getting it examined. So there's a lot of reasons not to file provisional. The reasons to file them are if there's a sense of urgency, you just disclose it that day. We've turned around patent provisionals in 1 day, believe it or not. Don't kill me. Only when necessary. Or if you're publishing a paper or you're getting a paper that's going to be reviewed, even by review board, I think you should file provisional first. So anything that's going to get disclosed or offered for sale, a lot of times it becomes a business decision to file provisional because we want to go and disclose this to our customer, and the customer's biting at the bit. They really need it. They want to know what it's about. Can we show it to them? No. Let us file provisional first, get it on file, disclose only what's in the provisional to the customer or less if you can help it, and then we'll convert that thing as quickly as possible. So those are the reasons why provisionals. It's kind of a quick and dirty hurry up thing. Otherwise, if you have the time and you could obtain the budget and the investment, go the utility route.
So you talk about the provisional. You talked about how you can go pro se. Is there anything, and this is technically a slightly more advanced topic, so I'll just hint at it. I'll let you go off on it and we'll pull back in. But if I'm a university student working inside the university using the university's resources, and now I've come up with this brilliant idea, and I reach out to John Maldjian to come help me with this idea, what are the things John's going to caution me about? You obviously said sales, making an offer for sale would be one thing. What else would you sort of say, if you are that person, think about these issues as well?
Absolutely. In an entirely different category of what we were talking about before with regard to how to protect the invention. I want to talk about the ownership of the invention. That's the very first question I ask any inventor. But when it comes to someone who's working at a university or at an institution or even at a company and they're coming to me as an individual, the first question is who owns the invention? And it's shocking sometimes to clients to say, well, what do you mean I own it? I invented it. Well, that may not necessarily be the case. Here's why. Yes, in the United States, he or she who invents is the original owner of the invention. However, by operation of agreement or employment contract or IP employment contract, you may have agreed to give away your rights to your invention in exchange for that job that you have, whether it's at the institution or at a corporation or at some other arrangement, a startup, for instance. So the first thing I ask my inventors is check your employment agreement, check your documents you signed on the way in when you met with HR, and see whether or not, and of course we'll take a look at them if we have to, see whether or not it says anything directed to who owns the IP. Should you create it at your job, on job time, using job equipment, etc.
So we've now reached a point. Let's say for some magical reason, it's not owned by the university. For some magical reason, you do have the money to pursue this, and you need the help of someone who's actually knowledgeable about patents. You then raise this idea, and you're going to call it a 101 issue, but when you are dealing with a product, how do I know it's even patentable? Where do I start?
Oh yeah, that's a good question. So, how do I know it's patentable? It comes down to three main criteria. The other two I talked about. But the first one is it patentable subject matter to begin with? And if you're talking about pharmaceuticals, the answer is yes. It's patentable subject matter, and that's distinguishable from is it anticipated or is it obvious. And I'm going to repeat those because they're jargon, and I want people to get familiar with those terms and what they stand for. So patentable subject matter is, does it fall into a category that the United States Patent and Trademark Office or the Congress, when they enacted the act, recognized as something that can receive a patent? Is it technology? Is it worthy of a patent? So, for instance, mathematical algorithms are not patentable, but the application of those algorithms are. If you find something in nature, you discover something in nature, you don't do anything about it, it's not patentable because it was already out there in nature. However, if you purify it, you modify it, you use it in something, then it may become patentable subject matter. So in the instance of pharmaceuticals, Taxol is a great one. Taxol was made from the bark of a tree, but they modified it, they purified it, they were able to duplicate it. So they were able to get a patent on the modified version of Taxol. And that's true in most pharmaceutical situations. Things that occur in nature, a molecule, for instance, that's just sitting out there, or an element, not going to get patented. But if you use that element some way, you break it up somehow, and you combine it, obviously, then you got something there. One other area, I know this is not relating to pharmaceuticals, but I want this to be a general discussion, as you mentioned, something called common business methods. Business methods used to be patentable, but unfortunately are now becoming more and more not patentable because of case law that just came out years ago and basically said it's not subject matter that's considered technical solution to a technical problem, so we're not going to give you protection anymore on it. That's been fighting in the courts and in Congress for the last almost 10 years now, since 2013 with the Alice case. Pendulum swinging back towards the favor of some business methods being patentable. But if you come to me as a client, I'm going to take a long, hard look at that to see whether it's patentable subject matter. So to answer your question again, how do I know it's patentable? The first criteria is it patentable subject matter. So an apparatus, a method, those are all patentable subject matters, as I mentioned. Mechanical devices, medical devices, all patentable subject matter. The next criteria is it anticipated? As we mentioned before, is it out there already? If it is, it's not patentable, it's old. And then the third question is, all right, you have a medical device, it looks pretty cool, but maybe somebody had something similar to that in one patent and then another thing in another patent, and together they make your invention. It might not be patentable because it's obvious. And that's, again, done through a patentability search. After we determine if it's patentable subject matter, we do a patentability search and we look at references to see whether anyone knocked out your invention or could be combined to make your invention obvious.
So you mentioned the Alice case. You mentioned this issue of patentability. My question to you is one of the issues both you and I deal with often are health tech companies. These companies who are saying, "Let me leverage technology to solve global problems." Um, what has been the impact of the Alice decision on health tech companies and the patentability associated with the technology that they have?
So when you say health tech, you're talking about like companies that do a lot of data and
Of course.
analysis of data. Okay. So I have a particular client that's in that space of data collection from cradle to grave. So even starting with the FDA trials, through the trials, and then over to determining where the drug gets sold, what regions, geographical areas, who's using it, how is it affecting them, and all that data becomes very, very, very valuable. In that it is something that can be used for further studies as long as it's de-identified and doesn't identify the patients from a HIPAA standpoint. Is it patentable? The question is, data itself is really not patentable. It's the manipulation of data that may be patentable. What I mean by that is, going back to the Alice case, if you're merely taking data and you're reviewing it and you're not doing anything different to improve the processing speed of a computer, for instance, or you've come up with a new way in which you're doing something, it, whether it's valuable data or not, it's not going to get you're not going to get a patent, most likely. It's when you use that data in a way that, again, is unique, non-obvious, and non-anticipated, but also advances technology. So it has to have something, what says something more. And there's a test now because of Alice. It went up to the Supreme Court. They've come down with a test of whether or not something does meet that criteria. That we could talk about at a detailed next meeting.
Absolutely. So we're obviously taking up a lot of time. So, but we've now reached the point where we go, is this patentable? If so, what makes it patentable? Now, obviously, this is my bread and butter. I don't want to give it all away. How much detail do I need to provide for this thing to be patentable?
Okay, so that's a good question as well. And this is something that is very tough for inventors, and I understand why. They're giving away their baby, so to speak. But unfortunately, it is a quid pro quo. If you want to receive a patent, you have to disclose a sufficient amount of detail of your invention, such that is written, enabling, and includes the best mode, and allows someone of ordinary skill in the art to reproduce your invention without undue experimentation. So, what does that all mean? Let me break it down. You basically have to tell someone, as if it was an engineering spec, how to reproduce something. If you don't give the details and you don't give the best mode, which is the best way in which you're implementing this invention, because as I mentioned, I think in our first talk, inventions are really abstract ideas. It's the embodiments of those abstract ideas that become what we could talk about in the patent application. Not to sound too esoteric, but so with that said, if you've come up with, I don't know, a mechanical device and you don't tell anybody how to cooperate the parts together for some reason, that's not going to get you a patent. So you have to disclose as much information as possible, so as to allow someone to reproduce this, like basically an instruction set. And a lot of times my clients want to withhold the secret sauce, or the what we call the special tool, which comes from a case where they withheld the special tool on how to do something, and the patent was found invalid because the person withheld information that was material to the patentability of the case, and also to disclose the full amount of the invention. So what do I mean by quid pro quo? You could keep whatever you've done as a trade secret, which I think we're going to have another podcast on. But a trade secret is the start of all inventions, the start of all patents. The invention is a trade secret. And then once you decide to go the patent route, you are agreeing to, at some point, disclose that invention, that trade secret, to the world or to the United States in exchange for that limited monopoly of 20 years from data filing. And then the purpose is to advance innovation to the United States or to the world by disclosing it to everyone. So you're disclosing it And then the government says, thank you for disclosing it and furthering innovation. Because of your disclosure, we will give you 20 years to do something with it, or whatever, 17 years, effectively, because it takes about 3 years to get a patent. So we're giving you a limited time to go and exploit this, but then we all wanted it in the public domain.
So you land up in a scenario where you have this potentially world-altering idea that's going to spread across like wildfire. In the case of, and this is slightly more advanced again, and these are sort of tips to where we might take these conversations. But what if it's COVID and we've come up with a patentable invention for people to use? Does the patent owner have to disclose it, when it's an urgency or extreme emergency?
It's a good question. I guess they don't have to, but if they start going down the route of, well, it depends. If you're working at a government institution, you have to disclose it. If you're working at an institution where you agreed with the government to disclose life-saving inventions, you have to do it. But if you're at your own private institution, you could probably withhold that. It would. Now we're getting into the morals of IP law, but you probably could hold it back if you wanted to. But let's say you do decide to go down the patent route. If it's something of value like that to national security, let's say, which a lot of times happens during wartime or in situations like this, when the AIDS epidemic came out, it was like this. With COVID, it's like this. The United States government has a right to pull the application and hold it in secrecy if it's, again, for national security. But they also have a right to kind of hurry things along and get this patent allowed, and then work with you on, for the common good of the United States, work with you on allowing you to have some rights to it, but they're going to basically commandeer it if they see the need for that. And so what they do is they offer what we call reasonable royalties to others to compensate you, the inventor, and probably all the research and development you did to get to that point. So it is somewhat of a fair compromise, but there is a possibility the government could kind of take it over.
So you're talking on Maldjian rights. Has that ever been used before?
Yeah, it's been used again in many times in the military, in national security. And I guess as of recently, I think it was used for the COVID situation, right?
Don't know. I'm gonna have to look into that a little bit more.
Yeah, me too. Okay. I'm not really sure of that, but yeah, Maldjian rights are definitely a consideration when you have something that revolutionary, like you said, that could save people, the planet, etc. Something similar to that is they will create categories like that are of need, and when that happens, they may not take your rights, or taking without representation and all that, but taking of land or property, but they will accelerate the process if you say this is relating to X, which we're trying to all solve here in America. And so they'll actually accelerate your process of getting a patent, which is really nice, because normally it takes about 2 to 3 years or more to get a patent on something. But if it's something in an area that the government is concerned with trying to find a solution to, they'll hurry it along without extra fees.
What is your incentive to actually hurry a patent along? I mean, I get the idea that you have a patent then, but you can say patent pending. Do you lose anything by saying patent pending?
Oh, you don't lose anything, but you don't really have any rights in the patent other than what's called provisional rights, and I'll explain that in a second. But until a patent issues, you don't have actually actionable rights against any third party for infringement. It has to issue from the government. It's literally like a letters patent. It's a grant from the government. Once it's granted, those rights begin. So if someone's infringing, the day you receive a patent, you can start suing them from that day forward. Provisional rights are a very obscure rule that says if the claims that you drafted in an original application end up in the patent, you might be able to go back to when the patent application was published and sue as far back as then, because the infringer had notice. But oftentimes those claims do not end up the same way as when you filed them. So a lot of times you can't invoke that provisional provision. So I barely bring that up with clients, but I do it for completeness sake. So for all intents and purposes, other than that exception, you do not have rights to sue or assert or license or what have you a patent until it issues. What patent pending does do, though, it gives you the right to put people on notice that you're trying to get a patent. And number two, it makes you look good in your field of industry against your competitors who may not have a patent pending. And three, it's very important for investors to see that you're attempting to get a patent on something. So I tell folks, get it filed as fast as possible because it's first to file these days, as well as it's a great sales pitch to say, hey, we got something here that's so important. We're trying to get a patent on it. And if we do, we'll be able to have an exclusivity out there in the marketplace.
So have you ever been in a situation where you saw that one of your clients' patents was, client's ideas was being used, you have a patent pending, and you send out a letter saying, we have a patent pending, we want to put you on notice that there's a patent pending, knowing fully well at the back of your head, I don't know if this thing's going to issue the way I want it to, but if I can use this as a scare tactic, that might be enough for my client for now.
Yes, we have, and you got to be very careful about that, and I'll explain why. First, let's remember that products and services infringe patents, but patents do not infringe other patents. And a lot of clients think that, well, if I get a patent, this goes back to your question about how is it a negative right? If I get a patent, I'm fine, right? Well, you may not be because of the pioneering patents we talked about earlier. But equally, you can't say, oh, someone got a patent, they're now infringing my patent. No, it doesn't work that way. It has to be somebody who's making, using, selling, or offering for sale or importing something that's covered by your claimed invention in your patent that makes it an infringement. So if they're doing that, what do you do if it's just patent pending? Well, you have to be honest and say we have an application pending, so they know that you're not able to assert your rights and start asking for damages. But you're putting them on notice and saying, look, if this issues, we will likely come after you and sue you for infringement. But obviously you can't do that now. So you can't be too harsh in that it sounds like you're misusing the invention or the patent application for threatening when you don't have the right to do so. But as long as you're honest and open about it with the alleged infringer, potential infringer, you can put them on notice. And I don't know if you want to get here, but what's great about this is if you are aware of somebody out there who would be infringing your patent application or your claims, you can modify your claims to map what they're doing right now if what they're doing falls within the original specification you filed. I know we're getting deep here, but a patent application, once it's filed, you can't change the spec and retain the same filing date. But you can change the claims if you have support in the spec, the drawings, or the original claims. So you have filed an application on, and the first claim is elements A, B, and C. And you see an alleged infringer out there who has A, B, C prime. And you're like, it's not exactly what we filed for, but that C prime is in our specification because we mentioned an alternative in our spec and it happens to be C prime. All right, let's draft some claims that say ABC prime and go right after the alleged infringer so that when the patent issues, you have that claim that is directly mapping their product or process.
And that's the value of hiring an expert to do these type of things, because someone who doesn't know what they're doing, if you're going in pro se, you might miss these opportunities and miss potential millions of damages. So John, just to sort of take it all back, how can people reach you to ask questions?
They can reach me at John.Maldjian at stevenslee.com. It's JOHN.MALDJIAN at Stevens, plural, Lee.com. Or they can reach me on my telephone number, which is, I think you put up there, is 609-718-0979. And I'd be glad to answer some of these questions for them and see if we can help you out.
And is there any place for them to meet you?
Oh, sure. My office is in Princeton. We can meet in Princeton, or I could always go to your facility wherever you're located. I love to see what technology is going on out there, and I'd love to get out of the office. So anytime you want me to swing by and see you, I could do that.
And you also are going to be speaking at an event.
That's correct. I'm not going to be speaking on, but I'm going to be supporting one of my shareholders who is speaking. But I'm going to be at the Select USA event next week, I believe. It's in June, last week in June, down in Maryland. It's a great organization, which basically talks to a bunch of companies that are looking to start businesses in the United States, and it's almost like a federal chamber of commerce, and we're there to help not give advice, but help to meet folks to potentially give advice on how to get started in the United States if you're coming from outside the country and want to start. So my particular shareholder that's speaking is Manuela, and she's speaking on immigration law, which is great. But then, I'll be down there to help talk to some folks about how do you get started on your intellectual property strategy.
That's awesome. Congratulations. And any parting words?
Parting words. Like we said, I like to encourage folks to try to do as much as they can on their own. In fact, most of the times I say, go do a search, then come back. But then you really should seek out a professional to help you, because as you can tell from this conversation, even on the high level, there's a lot of nuances. There's a lot of areas that you can get caught up in. There's a lot of areas you're not aware of, and you may do yourself some damage if you don't draft claims properly. You might draft them too narrowly, and then you'll miss out on intellectual property that you could have owned. And so it's probably better to seek out a patent attorney to help you along this process. And you'll be happy you did, because once you start building an arsenal of IP, especially patents, it really becomes a very valuable asset in your asset column of your business, one that you can leverage for multiple ways. Investments from others, you can use it as collateral for banking purposes. You can assert your rights, you can monetize it through licensing, or you could sell it and make money on your patents that way. And certainly, last but not least, you could enter into litigation where hopefully you ultimately win and receive damages and other rewards.
Wonderful. John, this was amazing having you on as always. Thank you so much for coming on. I'd like to have you on again soon.
I would love it. Thank you, Darshan. It was great talking to you again.
Pleasure.
Bye-bye.